In this week's module, we will continue our examination of the buyer's remedies in the event the seller breaches in a contract for the sale of goods, this time in a specific context where the seller breaches by making a non-conforming tender of goods that the buyer rejects. But before we get into the details, let's first start at the very beginning. Recall, in last week's module, we considered what happens where the buyer breaches by failing to tender the goods the parties contracted for, where the seller simply fails to show up with the goods. In this week's module, we will begin examining what happens where the seller tenders the goods, but the seller's tender is non-conforming, either because the goods themselves fail to conform to the requirements of the contract, or because the seller's manner of tender fails to conform to the contract. For example, the seller delivers the goods late or to the wrong place. As we previewed in our earlier examination of the UCC's gap filler provisions, when the seller tenders the goods, the buyer has a right to inspect those goods, to inspect the goods to determine whether the goods conform to the terms of the party's contract. After the buyer has had a reasonable opportunity to inspect the goods, and assuming the buyer determined the goods themselves or the manner of the seller's tender failed to conform to the requirements of the party's contract, then the buyer has a binary choice to make. Either the buyer must accept the goods, despite the nonconformity, or reject the goods. The buyer must do one or the other, and the buyer cannot do both. And as we will see later in this module, a failure to effectively reject is deemed acceptance by the buyer. From the perspective of remedies, this decision of the buyer to accept or reject is important, because the remedies available to the buyer will differ depending on whether the buyer elects to accept the goods or reject the goods. So in fact, where the seller makes a non-conforming tender, we have two scenarios to consider. In this week's module, we'll consider the buyer's remedies if the buyer rejects the seller's non-conforming tender. And in next week's module, we will consider the buyer's remedies if the buyer accepts the seller's non-conforming tender. So let's get started with the buyer's remedies where the buyer rightfully rejects the seller's non-conforming tender of goods. Where the buyer rightfully rejects the seller's non-conforming tender, the buyer's remedies are found in the same provision that we looked at last time, the same provision that outlines the buyer's remedies where the seller fails to tender the goods. That's section 711 of Article 2. Specifically, that section governs both the buyer's rights where the seller fails to make delivery of the goods, and also where the buyer rightfully rejects the seller's non-conforming tender of goods. So the buyer's remedies, where the buyer rightfully rejects the seller's non-conforming tender, are essentially the same remedies that we examined in last week's module. The buyer may cancel the contract. That means the buyer need not make any further payments that would be otherwise due to the seller for the rejected goods. Stated differently, cancellation means the buyer's obligation to perform under the contract is discharged and excused. And in addition to cancellation, if the buyer has already paid seller in part or in full for the rejected goods, then the buyer is entitled to recover that amount. And finally, the buyer will be entitled to recover damages from the seller, and the measure of the buyer's damages will be identical to the damages available to the buyer if the seller had simply failed to tender the goods. The buyer may cover for the rejected goods and recover cover-based damages pursuant to 712 of Article 2, or if the buyer does not cover, the buyer is still entitled to market-based damages pursuant to 713 of Article 2. In many respects, rejection is the worst-case scenario for the seller. Where the buyer rightfully rejects the seller's non-conforming tender, then the seller does not get paid for the rejected goods. That is, the seller will have to find something else to do with the rejected goods, maybe find someone else to purchase them, and the seller is liable to the buyer for damages. But this account of the buyer's remedies only scratches the surface of the party's legal rights and obligations where the buyer rejects the seller's tender of the goods. We'll look at those rights and obligations in this order. First, we will introduce the perfect tender rule. That rule articulates when the buyer has a legal right to reject the seller's tender of goods. Second, we will examine what the buyer must do to make an effective rejection of the goods. Third, we will see that where the buyer rejects, then in some cases, the seller may attempt to cure its breach. And finally, assuming the buyer has rightfully and effectively rejected the seller's non-conforming tender of goods, we will come back to the measure of the buyer's damages for the seller's breach.